Thank you. Everybody be seated. Okay, we'll have Commonwealth versus David Buck. Commonwealth versus David Buck, 24 CR 0017, 21 CR 00102. Are you David Buck?
Yes, sir.
Good morning. You were born in 1982?
Yes, Sean.
Last four digits, social security number 2125.
Yes.
You're here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Yes.
Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Your diversion was voided on February 13th, 2025. You are therefore sentenced to 5 years on each count to run concurrently for a total of 5 years. Okay,
There's no, see down, there's a plea.
2 years to run 24 CR 00102, an additional 2 years to run concurrent with 24 CR 0017. Okay. Okay, thank you very much. Stephen Chavez, which one is it?
There's a victim. Let's take a look.
Yeah, Megan knows that.
This is the one with the victim.
Commonwealth versus Stephen Chavez, is that correct, Chavez? Chavis, okay. This is 24 CR 0087. Mr. Chavis, were you born in 1981?
Yes.
Last four digits, social security number 6423.
Yes.
You're here today for purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole? Is it substantially correct?
Yes.
Do we have a victim statement? Where is that? The victim statement going to be read, or how's it going to be? Can we just stand to the left of victim statement?
Come forward.
Okay. Okay, would you identify yourself, please?
I am Judy Foster. I am on here on the behalf of Jimmy.
Wait just a second.
Your Honor, we have not made the opportunity to review the state events. We've not had the opportunity to review this report that you're given. If we can have just a few moments.
Do you have a written statement? Just hand it to her later, okay?
Yes.
Okay, ma'am, you may proceed.
Okay, I'm here on the behalf of Jimmy. Stephen Chavez, the known murderer of my sweet daughter Kyra Glover. There is so much I want to say to you. As I am writing this letter to you, the words cannot even harsh enough to express the depth of mine and my family's grief. The loss of Kyra has left a irreplaceable void within our hearts and lives. Every day since the passing of her has been marked by pain, disbelief, and overwhelming weight of her absence. Kyra was more than just a member of our family. There were moments with her that we were full of laughter and light. Her beautiful smile could light up a room. The memories that we share that Kyra now serves as fragile moments within our life. that was taken from us because you chose to take her life. Our family will always mourn, not only for the loss of Kaya, but for the future we will never get to have with her. Her bright smile, her milestones that will be uncelebrated, conversations that have gone unheard, and her big hugs that now must be unfelt. You took that away from us. Even though our grief is profound, we as a family believe in the necessary of justice that for our sweet Kaya. Justice needs to be served for her by punishing you. Kaya's family wholeheartedly hopes that you get the punishment that you deserve. Kaya's family is trustworthy that the court will consider the gravity of your actions for taking her life. Nothing can undo what you have done to Kaya, and no sentence shall be enough for you. Stephen, that baseball bat that you had in the back seat of your vehicle, we know that you had used it on Kaya prior to at the Union Church before you crashed into the tree and house in Fountain Run, Kentucky. Also on the scene of the vehicle, and put her in the driver's seat to make it look like she was driving. You are an evil person, and you will always be known as the murderer to our sweet Kaya. We carry our grief daily, but we always carry hope that this tragedy serves as a reminder of the life and consequences of the choice you made to take her life. May it to reflection, remorse, and perhaps in time, a path to understand the depth of the loss that you have caused.
Thank you, ma'am. Would you identify yourself?
That's what.
I'm Ashley McPherson. I was Kai's cousin.
Okay, go ahead.
I was just support.
Is that the same statement?
Yeah, it's the same one.
Okay, thank
Thank
y'all
you,
very
Ron.
much for your participation. You want to come back around? In 24 CR 87 for driving under the influence, you are sentenced to 14 days in jail to run concurrent with count 2. Under count 2, vehicular homicide, a violation of 507.060 Class B, 11 years to serve. Because of the seriousness of the crime, the court will not consider probation. Thank you very much. Dustin Cruz. Dustin Cruz, you want to come around? This is 24 CR 0055. Are you Dustin Cruz?
Yes, sir.
Good morning. Were you born in 1986?
Yes, sir.
Last 4 digits of your social security number 6473.
Yes, sir.
We have a pretrial diversion revocation. What says the Commonwealth?
Your Honor, Mr. Cruz is on pretrial diversion for wanton endangerment first degree. While he was on diversion, he, along with LaDonna Rich, engaged in a conspiracy to shoplift at Walmart in Bryant County. I have the officer here from the asset protection officer from Bryant County, Walmart, and the officer that arrested him. Also, Mr. Collins will need to testify about the omissions as who he was with. And the fact he wasn't employed.
Judge, we are asking for here.
Okay, we'll have it. Call your first witness.
Certainly, he was Jordan Webb. You want to take
You can stand right here. Raise your right hand, please. You swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
I do.
State your name
Jordan Webb,
and with whom are you employed?
Walmart Asset Protection.
Okay, go ahead.
How long have you been employed with Walmart?
I got employed during February of 2023.
And what's your duties with Walmart?
My job is to protect shrink, which presents theft at all costs, and to investigate theft in a matter that we are allowed to do so.
Did you have an incident on February 13th of this year?
I did.
And which Walmart is that?
Glasgow, Walmart store number 711.
Okay, and tell the court what happened.
Okay, so I observed Mr. Cruz come into the building. My job as an investigator when I first come in is to check our website, which is Aurora. I seen that Mr. Cruz had been keyed for an incident in Monroe County. There was no loss in Monroe County, but he had tried to commit theft. The event was keyed by Mr. Clay Prophet. I called Clay to verify that it was Mr. Cruz during this incident. I observed Mr. Cruz, and at the time that was the unknown female to me, select some items and put it in their buggy. Mr. Prophet advised that, hey, she has a backpack or kind of like a straw backpack that she carries. She'll put it in the buggy. Mr. Cruz will help her put the stuff in the bag and they will exit the building. Is exactly what they done. When they go to exit the building, they ditch their cart. I go to approach Mr. Cruz. He becomes hostile with me and they leave the premises. I notified GPD. And then I gave GPD my statement, the necessary footage I needed, and
Is that the gentleman which you had the problem with that day?
yes, sir.
When you said he became combative and hostile, what did he do?
He told me that he didn't know who he said some cuss words. He said he didn't know who the hell I was and just screaming at me and stuff like that. And that's when by policy, I have to back off and just alert GPD.
Have no more questions.
You have any inquiry?
I have a couple. Yes, Your Honor.
Yep.
Mr. Webb. You said that Mr. Cruz, used some hostile language. Did he
Yes.
ever become aggressive with you beyond
No,
language?
he was,
Don't say.
as he was becoming aggressive and hostile with me, he was backing up into the parking lot.
Okay. And, what is Walmart's policies and procedures with regard to beyond the store?
Okay, APL 9 policy, it states that if the gentleman starts to leave the premises, I am to know local authorities immediately.
Okay, and how much, items, what was the value of the items that were in total?
$40.97.
$40.97. Were those items, eventually recovered?
No,
Okay. I have no further question.
yes, ma'am.
Nothing further.
May he be excused? You're welcome to stay in the courtroom if you'd like, but you're excused. Okay,
Your Honor.
call you next week.
Call Officer King.
Good morning. You raise your right hand. You swear the testimony about to give us the truth, whole truth, and nothing but the truth.
I do.
Okay, lower your hand, identify yourself and whom you're employed.
I'm Officer Mitchell King. I'm employed by the Glasgow Police Department.
Okay, go ahead and start.
Officer King, did you get a request from Walmart on February 13th, 2025 for assistance?
Yes, I did.
And can you tell the court what you did?
Upon my arrival, I made contact with Mr. Webb, who had the video footage pulled up. He showed me the video footage of Mr. Cruz and a female that I could not identify, selecting items. They parted ways. The female went into the chip aisle where there's no video surveillance. She reemerged. They met up at the front of the store and exited the vehicle exited the front of the store heading towards the vehicle where Mr. Webb made contact with them.
After you observed the video and talked to Mr. Webb, what did you do?
Mr. Webb gave me the registration plate of the vehicle they got into. Upon that and the surveillance pictures, I ran the plate and confirmed that the male in the pictures matched Mr. Cruz's registration or driver's license photo from the registration.
And did you then obtain the rest of them?
Yes, I've applied for an arrest warrant for shoplifting.
I have no further questions.
Would you like to inquire?
Yes, Your Honor. Officer King, did you make contact with Mr. Cruz, during this incident?
No, I did not. I arrived after.
After? When did you make contact with Mr. Cruz?
First time physically seeing Mr. Cruz is today.
So he was not arrested on, February the 13th?
I did not arrest him, no.
Okay. The video footage that you reviewed at Walmart, did you obtain a copy of it?
Yes, and it's been logged into evidence.
I have no further questions.
Okay, can this officer be excused? Thank you for your attendance. You may be excused.
Call Officer Collins.
Okay, Officer Collins. Now raise your right hand. You swear the testimony about to give us the truth, whole truth, nothing but the truth.
I do, Your Honor.
Identify yourself with whom you're employed.
Chase Collins, I employ the probation and parole here in Monroe County.
Go ahead.
Mr. Collins, have you been supervising Mr. Cruz?
I have,
And for probably since July of last year, is that right?
correct.
Okay, during that time, has he ever reported any employment?
To my knowledge, no.
Okay, and has he got any restrictions about who he can be around?
Yes, he's not allowed to associate with any convicted felons.
Okay, and did he make any statements to you about this incident at Walmart?
He did. I sat down with Mr. Cruz, and asked him about the incident that occurred, the shoplifting charge. In that statement, there was a female that was in the statement that the officer had wrote. I questioned him about that, asked him who that may be, and he finally did tell me it was LaDonna Rich.
Okay, is he allowed to be around Miss Rich?
He's not supposed to be.
Why not?
She is a convicted felon.
I have no nothing further.
Do you have any questions?
Yes, Your Honor, I have one question. Officer, with regard to Mr. Cruz's employment, did probation ever offer resources to assist him with that?
If he had, as far as those resources, we have not, no.
Okay,
No.
I have no further questions.
Did he admit the shoplifting thing? Did
He did not.
what did he say happened there?
He just, if I can recall the conversation we had, he stated that, he didn't do it, and it was the individual he was with that did it.
Okay, thank you. Any other witnesses?
No.
You want to call any witnesses?
Judge, given the fact that Mr. Cruz has pending charges, then we are electing to not call him, but I would like to make.
Talking about the shoplifting
Yes, Your Honor.
charge, yeah.
Yes, just that is the only charge I'm aware
Yeah,
of, but it's still
obviously he
pending.
has the right not to testify. He can invoke that, but if he's going to deny doing it, I don't know why he wouldn't deny it here if he's going to deny it over there, but that's your choice. Okay, you have anything else you want?
I would just say, Your Honor,
That this case bothers the Commonwealth on so many levels. Mr. Cruz is not working, not making any attempt to work, going in Walmart, stealing to try to support himself. I don't know. And people say, well, it's only $40 at Walmart. These stores lose millions and millions of dollars and us pay for it. And as Commonwealth Attorney representing the citizens of the state, every citizen in the state has to pay for Mr. Cruz's conduct.
Okay, you
So
like,
I'd ask to be revoked.
Judge, I would like to make an argument in lieu of revocation.
well, that's why I called it.
Yes. Your Honor, I would ask the court to not revoke Mr. Cruz. The standard for revocation on a pretrial diversion is whether or not there has been a violation, and if there was a violation, whether that individual constitutes a danger to the community, and if he cannot be managed in the community. Probation did not testify that there was any supervision issues, and the violation report in this case, this appears that it was the first violation that occurred with Mr. Cruz since he was placed on supervision back in July of 2024. I believe that shows that he can be supervised.
Well, weren't there 3 violations here?
Judge, this incident is the first of
Well, I mean,
violation that occurred.
I mean, he hasn't been employed. He was supposed to be employed. He was associating with a known convicted felon and he was shoplifting. Those are 3 violations of his probation.
Judge, I am referring specifically to the violations that were included on the special supervision report. With regard
So I
to,
should ignore these other 2 violations that have been testified to.
Judge, this is not the argument I am making. I'm making the
I
argument that I
understand
can.
why you're not making that argument. Go ahead.
Judge, with regard to whether he is a danger to the community, while I understand the Commonwealth's concern about the loss that Walmart may have incurred and what the effects of that are, Mr. Cruz is being charged with a misdemeanor in district court, which, while it is a concern for someone that is on supervision, does not necessarily indicate that he is in fact a danger to the community. And I would like to remind the court that Mr. Cruz is currently considered innocent in the eyes of the law of that charge. There is a presumption of innocence until there is either a conviction at trial or an admittance of guilt. And I would ask the court to not revoke Mr. Cruz, instead issue a graduated sanction.
Okay, thank you. I'm going to revoke Mr. Cruz. It seems like to me he's not subject to being under the supervision. You know, obviously they've got the tape of him in action. His reaction to the officer when he was outside, and the fact that he failed to get any kind of employment, seek anything, failed to comply, was associated with convicted felon. So Thank you very much. Keith Gross.
Are you thinking that for final sentencing? It's you voided that
Yeah,
aversion.
that's, what is the next date we're gonna be, is it April 17th? April 17th, order pre-sentence investigation report
Thank you.
under probation and parole.
Just if I may approach.
What do you have? Just keep it there. Is that a
Okay.
plea?
It's a plea, yes, Judge.
Okay, are you Keith Gross?
Oh, yes, sir.
You born in 1979? Last four digits, social security number 6977.
Yes, sir.
Okay, you're here on 19 CR 0053, 18 CR 00160, and 21 CR 0061. Is that correct?
Yes, sir.
Okay, is there, I understand there is a plea, is it a felony plea?
Yes, Your Honor.
Okay. A motion's been tendered, sir, that says you wish to enter a plea today. Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is the plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the three indictments that I just
Yes, sir.
read? Is your judgment impaired today in any way?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea in this case. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go through the rights. And at the end, I'm going to ask you to understand. If any time during this time you wish a moment to step away and talk to your attorney, just say so, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called testify against you. Right to produce evidence. Right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
Now, we consider this Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I'll await a pre-sentence investigation report done by probation and parole. In the event after reviewing that I decide not to accept the recommendation and impose a harsher sentence, you have the right to withdraw your plea and go to trial. Do you understand that?
Yes, sir.
Mr. Hundley, are you going to deliver the Commonwealth? If y'all will move to your left there and let Mr. Hundley have the stage. Mr. Hundley.
Yes, Your Honor. Upon a plea of guilty to indictment number 21 CR 0061 on a charge of flagrant non-support, the defendant shall receive a sentence of 4 years. As of the entry of this plea, the defendant owes $11,128. The defendant shall pay child support in the amount of $11,128 once released from incarceration. Upon a plea of guilty to indictment number 19-0053 on a charge of theft of unlawful taking over $1,000 but less than $10,000, the defendant shall receive a sentence of 5 years. The 4-year sentence in indictment 21-0061 and the 5-year sentence on 19-0053 shall run consecutively for a total of 9 years to serve. The 9-year sentence shall run concurrently with Monroe indictment 20 CR-0098. The Commonwealth proposes shock probation or shock probation. The defendant shall receive credit for all time served in the above cases. However, he shall not receive credit for contempt time in any of the above cases. In relation to indictment number 19-0053, the defendant shall forfeit any personal property seized by the Tompkinsville Police. The defendant agrees to have any and all relevant evidence on the above title action disposed of in a manner consistent with the laws of the Commonwealth.
What property was seized by the Tompkinsville Police?
I believe it's a four-wheeler.
I think it's a four-wheeler.
I'd like to have that placed in the record just for transparency purposes. You know,
All right, what number is that?
I didn't bring all the files, so there's so many.
We didn't bring that file, but we'll do a written order and
so I'm not,
I may be wrong, I'm
I'm not,
It's on his board.
okay, well, that's why I'm saying, I'm not going, wait, okay. You're gonna like what I got to say if you'll just be patient with me. I'm not gonna forward anything until we see some proof shown and show it to you about who the owner is and what was that. I mean, this blank check thing doesn't get it, so we'll hold off on that, okay?
Thank you.
Yeah, thank you. Would you come around here? Is that what you agreed to, sir?
Yes, sir.
Okay. Are you pleading guilty, because you did in fact commit the acts charged as amended?
Yes, sir.
Okay. You're doing so your own free will. What is this?
I'm sorry.
Okay. In order your constitutional rights to explain to us, it's still your desire to give up those rights, enter a plea and allow the court to fix your punishment within the range permitted by law. You understand that after entering this guilty plea, any future convictions could be enhanced as far as range of penalty.
Yes, sir.
Is that your signature on the docket?
Yes, sir.
You accept, I'll accept the agreement. Now, are you, is he a state prisoner?
He is, Judge. I was gonna ask you about that. He'd like to waive the PSI.
Is there any reason why I can't do that?
You can't.
Okay, I'll go ahead and waive the pre-sentence investigation report and go ahead and enter the judgment so your time can start here. You fill that in as far as the charges, we'll get that right too, as far as the charges. I think you plead guilty to support charge and a theft charge. What was the other thing?
The sport charge and the theft charge, and then it's concurrent with the old case.
Yeah,
Or I guess newer case number, but old case,
theft over 1,000, but under
under 10,000.
10,000. Bring Jared Hill out.
We'll figure it out. Somebody else's name there.
Yeah. So they have got one.
See, this is not supposed to be from the years ago.
We'll figure it out. I'll let you know.
Yeah, I don't even know. Yeah, if I second forward, nobody's even got it.
Thank you, Judge.
Okay, Commonwealth versus Jared Hale. Are you Jared Hale?
Yes, sir.
Good morning.
Good morning, sir.
This is 24 CR 0092 and 24 CR 0089. Mr. Hale, were you born in 1984?
Yes, sir.
Last four digits, social security number 9494.
Yes, sir.
We're on a pretrial conference on this. What does the Commonwealth have to say?
I believe there's a request from the defense attorney. Is that correct?
Okay, go ahead. Okay, you want to move over this way?
Yes, sir.
Okay, go ahead.
Your Honor, given interactions with Mr. Hale and investigation we have done, communication with the Commonwealth, the information that we have obtained as a whole, we will be asking the court to enter an order for KCPC.
Okay, just an evaluation.
Yes, Your Honor.
You have any objection to that?
No, Your Honor.
Okay, I'll enter an order and they're probably, if we hadn't made them wait, Mr. Hale, till they take you up there, it'd be a while. So I guess we'll go ahead and try to do it. They're doing by Zoom now. Is that right?
Have to.
Have to do it by Zoom now.
They just issued new forms. I will send it. Okay, so hold off then. Yeah, I'll send it to you right now.
We'll talk about it.
Yesterday. I wrote it.
Well, I would run it by your attorneys first.
Going KCPC because, well, I know it's just, I already sent, I signed paperwork for y'all to send them to get my paperwork back from the mental hospital where I've been sent 2 or 3 times.
Yeah, they won't send you to KCP. They're gonna do it on Zoom.
Okay.
They'll do it that way. You don't have to go up there.
I've been in here for
Well,
6
not,
months.
we'll consider a bond after they do the evaluation. That's the reason that if we do the evaluation sooner, we can consider that source.
Yes, sir.
Okay,
Thank you.
okay. Diego Morales.
Yeah, you got the problem, she's waiting 2 minutes to record.
Cromwell versus Diego Morales, 24 CR 0038. Are you Diego Morales?
Yes, sir.
Good morning.
Good morning, how are you doing?
I'm blessed, thank you. Were you born in 1996?
Yes, sir.
Last four digits, social security number 5466,
Yes, sir.
represented by Mr. Garrett. Have you had an opportunity to look at the pre-sentence investigation report? Is it substantially correct?
Yes, sir.
Mr. Garrett, is there any reason this gentleman should not be sentenced?
No, Your Honor.
On plea of guilty possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 1 year. Upon plea of guilty possession of controlled substance, fentanyl, he shall receive 2 years. The 2 years, the two sentences shall run consecutively, a total of 3 years. I don't know how I feel about this fentanyl thing.
This is the case. I'll just give you some background, whatever the court's done finds with Commonwealth. This is the case where Mr. Morales had a lawyer initially that wouldn't show up,
Yeah, I remember that.
and we had a plea worked out. I think it was like 120 or 150 days. I don't know what the plea eventually agreed to. But because he showed up in court every time, trying to get his plea done, that's the reason we're gonna hit with him. So, basically cutting Mr. Morales some break off of that, but that's the reason.
Two sentences shall run consecutive, total of 3 years. Has he served his 90 days already?
He has, Judge.
Probated for 5 years. What does the court cost in this case? 240. Just pay, you need some time to pay that?
Yes, sir.
Okay, you pay it $50 a month, starting 30 days from date. You got a deal that I usually wouldn't accept because of fentanyl.
Thank you.
Don't you ever be in
No,
my
sir.
court again
I
on any
won't.
drug charge of any
No.
kind, especially fentanyl.
Yes, sir.
Okay.
Thank you.
Okay, he'll need to meet with probation and parole officer. When can he meet with probation and parole?
Your Honor, Monday in Glasgow.
Okay, we'll let him out Monday morning. What time?
9 o'clock.
Okay, I'll let you out at 8 o'clock on Monday morning and go straight to probation and parole office. Titan Neal. Titan Neal. Twenty-three CR 0060. Are you Titan Neal? Good morning. Born in 2001.
Yes, sir.
Last four digits, social security number 6027.
Yes, sir.
What does the Commonwealth have to say about this?
Your Honor, Mr. Neal has a 3-year charge on possession of a controlled substance. And he was placed in the specialty court. He's had about 4 or 5 positive tests. He was placed in rehab and he absconded. And that's when he was terminated from drug court. So we're asking that he be revoked.
And what do you have to say?
And Judge, with regard to Mr. Neal, we would be stipulating to the violations and agreeing to stand revoked.
Okay. Okay, it was probation, so you are sentenced to serve the time involved. Okay, was it 4 years? Is that correct? 3 years. Okay, 3 years. Thank you very much. Larry Nars. Commonwealth versus Larry Nars, 23 CR 0078. Are you Larry Nars?
Yes.
Good morning.
Good morning.
This is, were you born in 1992?
Yes.
Last four digits, social security number 1866. You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yeah.
Is it, counselor, is it substantially correct?
Yes, Your Honor, it is.
You are to receive 3 years probated for a period of 5 years supervised, and you shall follow all mental health recommendations, including but not limited to taking your medication and treatment. Do you understand that?
Sir.
What's the court cost involved in this? $195. I want you to pay, I'll give you some time to pay that. Start paying $30 a month. First payment is 30 days from today, okay?
Okay.
Okay, now when do you need to meet with probation and parole officer?
Same time, Your Honor.
Monday morning?
Yes,
Okay, I'll let you out of jail at 8 o'clock on Monday morning. Have somebody over there to pick you up and take you to probation and parole officer to go over the conditions, okay? Okay, thank you very much. Kyra Shockley. Kyra Shockley. Commonwealth versus Kyra Shockley, 25 CR 0014. You, Kyra Shockley.
Yes, sir.
Good morning. What's your year of birth?
8/18/98.
Now, your year of birth?
98.
Yeah, okay, and the last four digits of your social security number.
9921.
You need to speak up, man.
9921.
9921.
Yes.
Okay. You're here today for the purpose of arraignment.
Yes, sir.
At the indictment. So it's the information. We don't have a copy of the information.
Your Honor, I have a copy of the information here.
Yeah. You appear today here by information. The Commonwealth charges on the 25th day of February. You committed the offense of possession of controlled substance, first degree methamphetamine. Is that correct?
Yes, sir.
A motion has been made that says you wish to enter a guilty plea today.
Yes, sir.
Is this a pretrial diversion or a felony plea?
Diversion, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, sir.
Okay. Will you let her stand over behind the microphone?
Yes, Your Honor.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that was named in the information that I just read?
Yes, sir.
Is your judgment impaired today in any way?
No,
Have
sir.
you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Believe you've been fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. If at any time you need to step away and talk to your attorney, just indicate that. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial, but jury right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. By entering a guilty plea today, you give up all the rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept their recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, I'm going to ask you some qualifying questions here. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the last 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand if you successfully complete the diversion, the charges will be dismissed, pretrial diverted, and you can have your record expunged. You understand that?
Yes, sir.
However, if you do not fully complete the program, you're brought back in front of the court and I find that you violated and revoke your pretrial diversion, will be scheduled for a sentencing hearing, you'll be a convicted felon. You understand that?
Yes, sir.
Okay. What is the Commonwealth's recommendation? Mr. Stockton, you step to the left, ma'am.
Yes, Ms. Shockley will plead guilty to possession of controlled substance, first degree, receive a sentence of 2 years, pretrial diverted for 4 years. She'll enter and complete the Monroe County Specialty Program. She'll get credit for time served, obtain and maintain gainful employment.
Has she been voted in yet?
I don't know if she voted in or not. No, it's not.
Your Honor, I don't think she's been assessed yet. believe I had sent you a
Or she
referral.
stays in till then?
Yeah, we'll try to expedite it. So as soon as I get her assessed, I'll try to get her.
Okay. Ma'am, is this what you agreed to? Let her get back over here. Is this what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You plead guilty of your own free will.
Yes, sir.
I understand your constitutional rights, still you desire to enter a plea. Let me fix the penalty allowed by law. You understand if you are revoked out of the as far as your pretrial diversion, this would be a felony, can be used against you in the future. You understand that?
Yes, sir.
Is that your signature on the offer?
Yes,
I
sir.
accept the agreement. sign the order and we'll do the referral and have her evaluated. Thank you. Robert Tabor. Robert Tabor. I guess that needs to be put somewhere, sister. Things like that, it's a perfect one. Commonwealth versus Robert Taylor. Are you Robert Taylor?
Tabor, yes.
Tabor, excuse me. Good morning, Mr. Tabor. This is 25 CR 003. Mr. Tabor, were you born in 1987?
Yes,
Last four digits, social security number 3597.
yes.
You're on a pre-trial conference. What y'all have going? What's the Commonwealth have going on?
Your Honor, we had spoken with Mr. Stockton yesterday. We are in agreement due to the nature of the charges to pass this for one more negotiation and pretrial conference.
What is the nature of the charge?
Your Honor, the charges involve the distribution of child pornography.
Okay, and what's it come around here?
It's the Commonwealth's in agreement to pass.
Okay, so you'll
We
reschedule
thought we had a plea, but they need some additional time and we've also got some additional information. So
April 17th,
yes, and April the 4th for negotiation.
April 4th for negotiation day, and April 17th for the next court day. Okay, that's fine. Little Joe Williams. Arraignment. You are Little Joe Williams. You born in 1979. Last four digits, social security number 1121.
Yes.
We're here on 25 CR 0013 for the purpose of arraignment. The grand jury of Monroe County has charged you with possession of controlled substance, methamphetamine, count 2, possession of drug paraphernalia, count 3, possession of methamphetamine, count 4, possession of marijuana, and count 5, possession of drug paraphernalia. You understand those charges? Also, you have a probation revocation in 22 CR 0075. I understand these two cases have been wrapped together with a plea agreement. Is that correct?
Yes, sir.
Mr. Williams, a motion's been tendered, says you wish to enter guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol? You're gonna have to say something. This is a voice activated. You have to speak up, okay? Because when you hit the microphone, the camera goes on.
Okay.
You might be camera shy, you know. Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment 25 CR 0013 and 22 CR 0075?
Yes.
Is your judgment impaired today?
Yes.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes.
You understand you don't have to plead guilty today. You have certain rights in the Kentucky United States Constitution. I'll go over those rights, and then if you understand them, I'll ask you, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, or right to call witnesses, the right to appeal this matter to higher court. If you lose, you have a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charge. But you understand that by entering guilty plea today, you give up those rights. I may consider the Commonwealth's recommendation, but I may apply and arrange a sentence allowed by law. Prior to accepting your recommendation, I'll await a pre-sentence investigation report to be done by probation and parole. Event after reviewing that, I decided not to accept the Commonwealth's recommendation and decided to impose a harsher sentence. You have the right to withdraw your plea and proceed to trial. You understand that? Okay, who's going to present this for the Commonwealth?
I will.
Move your left there a little bit, Mr. Williams. Be careful now.
Your Honor, upon a plea of guilty to information, that's 25 CR 13, possession of a controlled substance, namely methamphetamine, and also has a district court number of 23F-0015. The defendant shall receive a sentence of 3 years. Upon a plea of guilty of possession of a controlled substance, methamphetamine, on the charge in District Court 25-0012, the defendant shall receive a sentence of 3 years. The 2-year sentence and 3-year sentence shall run concurrently for a total of 3 years. He shall serve 45 days in jail with the balance probated for 5 years, probation to be supervised. The 45 days in jail shall run concurrently with the 45 days sanctioned Monroe indictment number 22 CR 0075 for a total of 45 days to serve. This 3-year sentence shall run consecutively to action number 22 CR-75 in the Monroe County indictment. Defendant shall enter and complete long-term treatment facility determined by and scheduled through DPA and agreed upon by the Commonwealth. Probation and parole shall transport the defendant to the treatment facility after the service of 45 days. The defendant shall receive credit for time served, shall obtain gainful employment, or do a minimum of 30 hours a week community service. And he agrees that any evidence collected in these matters be disposed of in accordance with.
It's 45 days from today, or does he get credit for time he's already served?
He'll get credit for any time served.
How many days does he serve?
He's been in since the 25th of February, Your Honor. I think we have been a couple of weeks of work.
Is that your understanding of the Commonwealth's recommendation? Are you pleading guilty because you did commit the acts charged in the indictment as amended or information?
Yes.
You're doing so of your own free will?
Yes.
Well, your own constitutional rights explains it's still your desire to give up these rights to enter a plea of guilty to charges and allow the court to fix your punishment. You understand that after entering a guilty plea here, any future felony convictions could be enhanced under persistent felony offender law. You understand? Is that your signature on the docket? I'm going to accept the agreement order pre-sentence investigation for schedule a sentencing on April 17th. So I guess he will have his day served by April 17th, so he can be expected to get out on April 17th. So I have somebody here to pick you up.
Hey, Your Honor.
Well, Joe?
I want to thank you for letting me go to the funeral.
Yeah, well, I'm sorry. I was gonna say, I'm sorry about your loss. But here's the deal about it, man. You're still a relatively young guy,
Yeah.
and you can turn this thing around. You don't have to be up here all the time.
I'm not
to get
going to.
permission.
This is
Well,
my
I
last
hope you don't.
It's
But
my
you
last
got-
straw.
Still, you know, from what I was told, you still got a lot of people that care for you, care about you, and you're lucky to have that, okay? Some people don't have anybody left, you know? Okay,
It meant a lot to me.
okay,
When Bethany called me and told me that y'all agreed to let me go to the funeral.
okay. Well, good luck to you. Try to work it out. Okay, do we have anybody else in custody?
This is not the, too late to tell them. Yeah, that's beyond negotiating. I'll chat.
Did you say we had a bonus from transport?
I've changed it.
Yeah.
We don't have a bonus.
Yeah,
Correct.
but I had already added.
Oh, it said it. Okay, I got you. I got you. Is that it?
That's all about.
Okay. Deanna Baldwin, Commonwealth versus Deanna Baldwin. Commonwealth versus Deanna Baldwin, 25 CR 007. Are you Deanna Baldwin?
Yes, sir.
Good morning. You were born in 1973.
Yes, sir.
Last four digits, social security number 7565.
Yes, sir.
You're here to be arraigned today. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with trafficking in methamphetamine, a Class B felony. And these charges are enhanced pursuant to 28-218-89-92 for possession of a handgun at the time of the offense. You understand those charges?
Judge, we are resolving the entirety of the case, including the new indictment today. We have a pretrial diversion.
Is this a superseding indictment or an additional indictment? What's the story here? Had she been previously arraigned in another case?
Yes, Your Honor, this is a superseding indictment.
Tell me about it.
There was, Mr. Hunley started marking up.
Did you come around here?
Yeah. Mr. Hunley started marking on the indictment before it made it to your desk for processing, so we had to go back and redo the indictment. Simple as that.
Is there a plea offer here? Is it? A motion has been tendered says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that was just identified in 24 CR 00103.
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you discussed this matter with your attorneys and are you satisfied with their advice?
Yes, sir.
Review the evidence Commonwealth has against you. You believe you've been fully informed about your case.
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. The right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges. You understand that by entering guilty plea today, you give up all those rights. You
Yes,
understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence providable. I don't have to accept any recommendation. Prior to accepting your recommendation, I'll wait a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Would you move to your left? What's the Commonwealth's recommendation?
Trip on that. Your Honor, upon a plea of guilty to trafficking in methamphetamine first degree first offense, the defendant shall receive a sentence of 5 years pretrial diverted for 5 years supervised. The defendant shall enter and complete the Monroe Specialty Court. Additionally,
So this is a pretrial diversion.
it is. The defendant shall forfeit the Glock 19 5.59 millimeter with serial number AFTK 004 and a 9 millimeter magazine and 13 silver hollow point shells to the Commonwealth and disposed of in accordance with the laws of the Commonwealth and the holding agents. The defendant agrees to have any and all evidence in this above case forfeited and destroyed in a manner consistent with the laws of the Commonwealth of Kentucky, and she shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is.
What was the quantity of drugs he had?
I believe it was 7 grams.
5.
5.
And where was the gun?
I don't know, Mr. Hunter, you know, you negotiated this case.
Judge, I can answer this question. What happened is Miss Baldwin was locked out of her truck. The methamphetamine and the gun was inside of her truck. She had called for a locksmith, and it is my understanding that she had called 911 to get a number. She'd called the police department to get a number for the locksmith. There was not one available, so they sent officers out where they viewed the methamphetamine and the gun. Miss Baldwin at this time was traveling between where she was living in Simpson County down into Clay County in Tennessee, taking care of her sick grandmother, and had the gun
Is
with
that the
her.
reason she had a gun to take care of her sick grandmother with her methamphetamine?
Yes, Your Honor, if you'll let me continue.
I'm not gonna go with this. I'm just not gonna go with it. You don't need to come to Monroe County with a Glock and some dope and expect to walk out of here on a pretrial diversion, so we'll set it for trial.
Judge, if the court is not agreeable to accepting this plea, I think it is possible that we could still resolve this case in a manner that would not require trial.
I'm willing to listen to a plea if you wanna renegotiate the thing.
Yes, Your Honor.
I'll set it over till April 17th, negotiation day on April 4th.
Okay.
Is there any complaints about our bond?
No, not to my knowledge.
And Judge, for the court's knowledge, she is currently employed.
It's good.
Everything is fine. Right?
Joshua Bryant. Hello versus Joshua Bryant, 24 CR 00103. Are you Joshua Bryant?
Yes, sir.
You were born in 1986.
Yes.
Okay, the last 4 digits of social security number 6756.
Yes.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report number probation and parole?
Yes.
It's substantially correct.
Yes, sir.
Okay. Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
Upon plea of guilty to trafficking controlled substance, 2 grams of methamphetamine should receive a sentence of 10 years, probated for 5 years. Defendant agrees to having all evidence destroyed. What was the quantity in this?
We opposed.
Yeah, okay. Hold on a second. Everybody check this. Okay. Okay, when can he meet with probation and parole?
Your Honor, I can meet with him this afternoon at 1 p.m.
Can you be at the probation and parole office at 1 p.m.?
Sure.
What's the court cost in here?
$185.
$185. You need some time to pay that.
Yes, sir.
Okay, you pay $50 in 30 days from day and $50 every 30 days until you get it paid, okay? Okay. Larry Butram. Monroe versus Larry Butram, 24 CR 0093 for sentencing. Are you Larry Butram? Yes. Good morning. You born in 1973? Yes. Last 4 digits, social security number 7817? Yes. You get an opportunity to look at the pre-sentence investigation report number probation parole. Yes. Is it substantially correct? Yes. Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On possession of controlled substance, first degree, first offense, methamphetamine, defendant should receive 1 year probated for 1 year. Receive credit for time served, evidence destroyed. What's the court cost in this case? $215. You need some time? pay $50 within 30 days and $50 every month till you have it paid in full. You'll need to meet with a probation and parole officer. When can he meet with you, officer?
1:15.
1:15 today to probation parole officer, okay? Thank you very much. Lisa Chapman. Lisa Chapman. Commonwealth of Kentucky versus Lisa Chapman, 24 CR 0. She's here for arraignment. I'm seeing. That's actually sentencing. Is there another arraignment charge or just sentencing?
It's just sentencing, Your
Okay, it
Honor.
was just mistyped. You born in 1968, ma'am? What's the last four digits of social security number?
1142.
Do what?
1142.
1142. You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report? Y'all are keying that microphone over there if you don't mind. Have you had an opportunity to look at the pre-sentence investigation report under probation? Is it substantially correct? Is there any reason why this lady should not be sentenced today?
No, Your Honor.
On a plea of guilty to possession of controlled substance, first degree, first offense, methamphetamine, she received 2 years probated for 4 years supervised. Shall enter and complete the Monroe County Specialty Court. Has she been voted in yet?
She was voted in.
And so you'll go to the orientation. They'll tell you when the orientation is. You'll receive credit for time served. What are the court costs in this case?
165.
100 and what? 165. You need some time to pay that.
I can pay the 100 today and then.
Well, you don't have to do that. I don't want to put you in a hard place, okay? So you pay $30 within 30 days of today and $30 every month until you get it. Or you can pay it all if you want to. It doesn't matter, but you know, there's no use putting a squeeze on anybody. You're already fixing to take under these new obligations. So you need to, I need to give you something that you can do. No reason to start off failing, is there?
Thank you, I appreciate it.
Okay, no problem. You meet with the drug court, but you need to give the probation parole officer certain information, okay? He's right over there. Jamie Piercy. Commonwealth versus Jamie Piercy, 20 CR 0021. Are you Jamie Piercy? Were you born in 1987? Last four digits, social security number 9146. It says we're here for review, Mr. Stockton. What's the story?
Yeah, he was supposed to pay on child support and I think he's made a late payment according to his counsel.
What's the story here?
Your Honor, Mr. Piercy has told me that he made some significant payments towards his child support yesterday afternoon. However, child support, who I contacted earlier this morning, told me that those would not process for them to be able to see until at least tomorrow. So we're not able to get the
The
confirmation.
county attorney's office?
I contacted the child.
Is that where they pay? Is that the child support office at the county attorney's office that we're talking about? Okay, how much did you pay?
It was like $1,200 altogether.
Yeah, well, let's set it for review, and if your check comes back or whatever, you know, we'll know where to find you.
If you want to pay it consistently and provide proof of payment, we can do an agreed order, continue to another date where you don't have to come here.
Well, okay, well, let's schedule it out for June the 12th.
Okay.
Schedule to be back, and if you paid up and in the Commonwealth, your attorney can contact the Commonwealth, see if you have to be here or not. If you're paid up, keep paying it, you won't have to come back. I know you're gonna miss us if you don't have to come back, but,
Yeah.
okay,
Thank you.
okay, no problem. Jose Guano says that he's been visited by ICE, is that correct?
He's in Boone County, that's Mr. Bell's corner. I don't want to-
Motions.
Johnny Bell, you got a case up here. You filed in 24 CR 0031 and 98, you have filed what is called a motion for relief.
Motion to set aside the judgment under 6002, Your Honor.
I filed that, yes, sir.
Tell me about it.
Judge, we had
Say
Mr.
your client's last name.
Guano.
Jose Guano?
Yes, sir.
Okay, go ahead.
Mr. Keanu came in, Judge, and we worked out a deal and we worked very hard, both me and the Commonwealth and him. And we got a solution worked out on a pretrial diversion, and there was some collateral reasons why that we done it the way we did it. We had all been very interested in a body cam, and to look at that and review that because of the allegations. It would help us and aid us a great deal making a decision, both from the prosecutor's standpoint and from my standpoint and my client's standpoint. Well, we were told, that
I'm not following you here. I'm sorry. So.
okay,
He did a pretrial diversion, right? Or did he?
we done a pretrial diversion.
You did a pretrial diversion.
Yes,
and then
sir.
What happened?
He went to probation and ICE was waiting on him. They picked him up and put him in custody with ICE
Okay,
based upon the charges.
okay.
That was our greatest concern and the reason that plea negotiations went along as far as they did, because he's got 5 kids here in Monroe County. He's always worked. He's always done what he's supposed to, aside from these circumstances that landed him here. And that was a big part of our
Well,
negotiations.
what do you want me to do now?
Well, the officer in this case has made statements, both in writing and in reporting. After we had done the plea, I think he had made a statement to Mr. Stockton. This is just a hearsay situation, that he made those very early in the case, which can't be true because he references the INS and the situation of him being picked up, which happened well after we entered the plea. I had assured my client and his family that there was no body cam because that's what I had been told, and I think truthfully by the prosecutors. Then this same officer made a recording that was recorded by my client's wife, stating that he had given the body cam to Mr. Stockton and that he had no responsibility to turn it over to us, and even went into detail about what's on it, which is part of our motion. And that put me in a very bad situation because my client then says, you know, I didn't do my due diligence.
Mr. Stockton.
And Judge, I don't want you to resolve this, just
What's the story on this thing?
Well, the old proverb is, there's no good deed goes unpunished.
Because we negotiated this thing with Mr. Bell, and we took into consideration, and we finally agreed on home incarceration because Mr. Bell was afraid if we put him in jail, he'd be deported. And that's what we ended up agreeing to. And Miss Vanderpool, who I can get on by Zoom, she's at a doctor's appointment this morning. She checked 3 or 4 times to make sure there wasn't any body cam. And even checked after the fact, and there's never been any body cam in the portal that we check. And the way she explained it to me is when an officer places their body cam to be recharged, it downloads automatically into their system. So for there to have been body cam and us not had it, there would never have been placed back in the system. So as far as we know, there's not any, and Mr. Hunley can go through the rest of it as far as what Mr. Hammer's done.
So if there's no body cam, that's the story.
well, Your Honor, if there's no body cam, and I believe what Mr. Stockton's saying. I'm not saying anything about the Commonwealth in this situation or circumstance, but what I am saying
It
that
looks
Mr.
like you're talking about him. Mr. Hunley looks like you're talking. Do you feel like he's talking about you?
No, I told them up front what this situation was, Judge.
Well, I don't understand.
This officer, Mr. Hammer, cannot come out in public and state that there's items of discovery as a criminal defense lawyer, and me look at my clients and say, I assure you, there's no body camera. I've talked to Mr.
I'll
Stockton, I've
scold
talked to
him.
Mr.
I'll
Hunt.
scold him for doing.
Well, that don't do any good to my client,
Well,
Your
let
Honor.
me tell you what, it doesn't affect your client if the underlying facts are not changed.
Well, how do I know that there isn't a
Well,
body cam? Just
You
because you
shouldn't
wouldn't
listen to-
download
You
it?
shouldn't listen to idle chatter from these people. Officers should,
No, that, you know,
your motion is denied.
well, Judge, I'd like a written order on that.
I'll give you one.
I appreciate it.
It won't be by the end of the day, but you'll get one.
I don't want it by the end of the day. I can't use it before the end of the day anyway, but I would want a written order, Judge. I appreciate it.
Get one.
And Mr. Hammer don't even have to take the stand and answer any of these charges.
Well, what do they have to do with anything? What do they have to do with anything?
If he
Wait,
has
here,
hidden
what-
evidence or destroyed or manipulated evidence, that is a crime. And that puts me as a criminal defense lawyer in a terrible
You can
situation
report
with other
that, you
clients.
can report that to the Commonwealth Attorney's Office and ask them to do an investigation. And if you want a special if they feel like they've got a conflict, they can request a special prosecutor, which I think might be appropriate, Mr. Bell, to give some confidence, you or your client, there would be an appropriate investigation to see if there was anything withheld.
I hope you can see my situation and my
I do
circumstances.
see your situation, but you know,
And he's got to make a knowing, intelligent, voluntary plea, but if there's all the evidence about him turned over to the Commonwealth and not to us, there's a problem there. There's a break in the chain.
Draft a letter next week to Kentucky State Police. And I'll ask them to investigate this matter and see if there's any tampering with physical evidence. And once I get a report from them, I'll request a special prosecutor. And then we'll find out if there's been any wrongdoing occurred.
that seems fair enough.
Does me too.
There should be anything done on simply that, Your Honor, unless you have an evidentiary hearing establishing that there was a body cam.
But we'll find out with
We
the
can't
state.
prove the negative. There
Well,
was.
I denied his motion other than just slur him. I don't know what I can do. I denied his motion and he thinks that there's been something untoward. I think what the Commonwealth Attorney says, he asked the state police to find out if there was, they can do an investigation.
Don't think there was, but that way we'll know.
We'll know, they'll give it
All I'm
independent.
asking
Well,
is
that's all,
you
you're getting it. You're
Right.
getting it, yeah. Gerald Ryan.
He's deceased, Your Honor, at least I hope. What
We had we sent you an order.
Mr. Ryan is deceased.
Yes, Your Honor.
Yes.
That's your client, Mr. Garrett?
Yes, Judge.
Would be an order submitted dismissing those charges because he's
Yes, Your Honor, we submitted it.
Chad Shirley.
We might have to redress this key article from the because if I will ask for an investigation, we can do this.
Find out, we'll, I don't know when the legal fees suspended. We'll find out, get the policy. We're not investigating, we're just investigating the circumstances, so.
I'll talk to Kyra.
Are you Chad Shirley?
Yes, sir.
You were born in 1990?
Yes, sir.
The last four digits, social security number 4625.
Sir.
This is 24 CR 0029. Mr. Bell, you have filed a motion for a continuance.
So we filed that, Your Honor.
You filed it, okay. tell
We
me-
have no
wait,
objection.
The last examiner was.
Come around here, see, you know.
He couldn't be present that day.
Did we have a trial set?
Yeah, March 25th.
Okay, well, let's just go ahead and reset now.
Judge, if I may address the court very quickly, during the time that I was talking to Mr. Hunley about this, he did make me an offer in this case. I talked to my client about that. He has wanted me to make a counter offer. I would ask the court to put it back on for that April date before we set another trial date.
I mean,
That suits everybody.
That's fine with us.
wait a second, wait. Can't get my calendar. We got a tragic situation here, my calendar.
I'm sorry, but the motion was without any objection as far as continuing.
Wait a second, guys. It's coming out now.
I don't, Jesse, you got any problem taking that thing to monitor?
I don't. Ain't going nowhere.
What date was it set for?
What we do.
March 25th.
Probably.
And on this table, is it what you said?
Big police investigation, and they tell you what it matters.
You know, I don't.
That's all.
Okay, what do you want to do with it again now?
Set it for April the 4th.
April 4th for negotiation, April 17th for the next court date. If we don't have an agreement, we'll set a trial date on.
Yes, sir, Judge. Judge, we also have an agreement, if it pleases the court, to allow him to take his ankle monitor off. He's
What's the
had,
charge?
It's a traffic and a criminal syndicate case. I don't think he's a flight risk, and there's not been any violations of the law that we know of since.
What's the
Van
here?
Horn.
What's the quantity here?
I can't remember.
300 pills.
300 pounds.
What kind of pick?
Hydrocodone.
All goes out of the Miller.
300 was an aggregate of the whole investigation, was it not? Not just what, that wouldn't be all on Mr. Shirley, because we know there's other places that.
Where you live, Mr. Shirley?
848 East Vashon Road.
Here in
Yeah,
Monroe
it's out
County?
behind Joe Harris.
Are you working anywhere now?
Yeah, I've been at Dart for a year.
Okay, well, since you're working, we'll take that off, okay? So you want him there on April 4th, do you? Or you want him on April 4th?
Yes, sir.
April 4th for negotiations and April 17th, your next court date, okay? Okay, Kyle Simmons. Kyle Simmons. We need to go to probably the Christian County Detention Center if they're on there. Just have Mr. Simmons sit down there for a second. Christian County Detention Center, are you on there?
Yes, we are.
Okay, will you turn your camera on?
It's on.
There you go. Thank you so much. Commonwealth of Kentucky versus Stephen Brown. Are you Stephen Brown?
I am.
Were you born in 1980, Mr. Brown?
I was.
Last four digits, social security number 0396.
Yes, sir.
Mr. Bell, is this your client?
Oh, I did recommend that. I have sometimes.
Well, this is a probation revocation.
Yeah,
It's
it's also
arraignment.
arraignment also.
And an arraignment, since he's incarcerated, I'm gonna appoint a public advocate. You've seen Mr. Brown identified, correct?
Yes, Your Honor.
Mr. Brown, you have a right to remain silent. We're just gonna read the charge on you, and then your attorney here, public advocate, will be in contact with you. If you desire to have a private attorney, you can tell her that, and you can make arrangements for that, okay? The grand jury of Monroe County has returned an indictment charging you with trafficking and controlled substance first offense, first degree, second offense, fentanyl, or complicity to trafficking controlled substance, first degree, second offense, fentanyl. Do you understand what that charge is?
Yes, but I ain't never had a
Wait. Don't say anything about, I'm just asking if you understand, because I don't want you to say anything used against you, okay?
No, I understand that. I just don't understand how it's a second offense.
Well, I don't either, but
And Mr. Brown, we will discuss that with you.
I'm just telling you, they might have charged you wrong. I don't know. You know what I mean? But your attorney will talk to you about that. You acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We'll set a negotiation day on April the 4th. Next court appearance on April 17th. Your attorney will be to see you, Mr. Brown, okay?
Thank you, Your Honor.
Okay, Christian County, thank you very much for your cooperation. You may be excused. Okay, let's go back here to Mr. Simmons. Mr. Simmons, you want to come up around? Commonwealth versus Kyle Simmons, 24 CR 0053. Good morning, Mr. Simmons. Were you born in 1990?
Yes, sir.
Last four digits, social security number 8515.
Yes, sir.
You're here today for review. What's it come with it?
Your Honor, all the information I've been furnished is Mr. Simmons is doing well. He's done everything requested by the Commonwealth. And we just asked that if we don't want to withdraw our motion at this time, but we could continue in a couple of months so he can furnish the appropriate paperwork.
May 15th.
Yeah, that'd be fine.
May 15th, be back here on May 15th. Talk to your attorney about making sure that you need to keep in compliance, okay? Robert Simpson. Caldwell versus Robert Simpson, 22 CR 00107 and 24 CR 0079 for pretrial conference. Mr. Simpson, were you born in 1991?
Yes, sir.
Last four digits, social security number 5031.
Yes, sir.
What's the Commonwealth had to say?
There's some issues that I've discussed with Ms. McCauley.
Speak up just a little.
I'm doing the best I can.
I understand that. If you get close to that microphone, get right down there.
Could we pass this for about 2 months and we should be ready to either see what we need to do?
April 17th. No, May
date would be better.
May
Judge.
15th.
Thank you.
Okay.
Thank you, Judge.
Do you have a negotiation date for May yet?
No, it'll be the first Friday in May.
First
May
Friday?
9th.
Yes,
May
Or the
9th,
May 2nd, which one?
May 2nd.
May 2nd. okay.
May 2nd, and then May 15th. Ronnie Thompson. Commonwealth versus Ronnie Thompson for sentencing. Oh. Are you Ronnie Thompson? Good morning. You're here on 24 CR 001000101. Are you born in 1963?
Yes, sir.
Last four digits, social security number 3683.
Yes, sir.
Are you here for sentencing? Have you had an opportunity to look at the pre-sentence investigation report of a probation and parole? Is it substantially correct? Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty possession, controlled substance, first degree, first offense, methamphetamine, you shall receive a sentence of 3 years, probated for 5 years, and you are to enter and complete SAP IOP. Receive credit for time served. What's the court cost in this case?
215.
215. You need some time to pay that. I'll let you pay it $50 within 30 days and $50 a month. You have it paid in full, okay? You can meet with a probation and parole officer.
And Judge, there may be a cash bond. The court could release that as well.
They'll hold all the court costs out of it.
Okay. Hey, Ronnie, you want to take your court costs out of the bond?
He doesn't have any choice. He's going, if it gets released, it's gonna be taken out. Question is you want the rest of it or you want it to stay over there? That's the question. Yeah. Yeah. Unfortunately, Ronnie, you ain't gonna get much of it. I can tell you that right. I can see that coming. Okay, Commonwealth versus Steve Vincent. Okay. Commonwealth versus Steve Vincent, 24 CR 0095 and 24 CR 00100 and 25 CR 0011 for arraignment. You have a right to remain silent. You are Steve Vincent, is that correct?
Yes.
Born
Yes, sir.
1981, last four digits, social security number 5460. Grand
Yes.
jury of Monroe County charged you in 25 CR 0011 with possession of controlled substance in the first degree. Mr. Bailiff. You acknowledge that any client received an out of the way form or, okay?
Yes, Your Honor.
Now I understand that
We have an agreement.
a wraparound
Yes.
thing. Is this a felony plea?
It is, Judge.
Motion been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes, sir.
You currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in these three indictments that I just called a second ago?
Sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these matters with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes,
You
sir.
understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand these rights.
Yes.
I'm gonna go over them, and after I finish, I'll ask you if there's any time in between you want to step away and talk to your attorney, you just inform me, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to acquire a Commonwealth prove on a reasonable doubt that you're guilty charged against you. Understand it, but in a guilty plea today, you give up those rights. Is that correct? I may consider Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept any recommendation. Prior to accepting any recommendation, I'll order pre-sentence investigation report from probation parole. In the event I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Okay, you understand that? What is the Commonwealth's recommendation? Somebody will come around.
Your Honor, on 24 CR 95, he'd receive a sentence of 2 years on possession. 24 CR 100, he'd receive a sentence of 2 years on possession. On 25 CR 11, he'd receive a sentence of 2 years on possession. They would all run consecutive for a total of 6 years. Probated for 5 years, supervised, he would enter and complete the Monroe County Specialty Court and receive credit for time served.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
For doing so, your own free will.
Yes, sir.
Knowing your constitutional rights explains it's still your desire to waive those rights, enter guilty plea, and allow the court to fix your punishment in the range permitted by law. You understand that by entering a guilty plea today, any future convictions could be enhanced in a persistent felony offender law. Do you understand that?
Yes, sir.
Is that your signature on the docket?
Yes, sir.
Order a pre-sentence investigation report to be done and scheduling with sentencing on April 17th. Meet with the probation parole officer over there.
Thank you, Your Honor.
Remain on the same bond. Eric Wells. Eric Wells. Commonwealth versus Eric Wells, 24 CR 00104 for sentencing. Are you Eric Wells? Good morning. Were you born in 1974?
Yes, sir.
Last 4 digits, social security number 3768.
Yes, sir. Yeah.
Have you had an opportunity to look at the pre-sentence investigation report number probation and parole?
Yes,
Is
sir.
it substantially correct?
Yes, sir.
Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Now, you were informed that that this DUI was enhanceable, correct? You get it? Okay. Upon a plea of guilty to operating motor vehicle, under the influence, defendant shall pay $200 fine plus cost. Upon a plea of guilty possession of controlled substance, he shall receive a sentence of 3 years. Upon a plea of possession of controlled substance, hydrocodone, here, the 2-3 shall receive 3 years. 2-3 year sentence shall run concurrently. With 3 years probated for 5 years. The defendant shall receive credit for time served. What is the total cost of fines and things in this case? Do what? $835. Will you need some time to pay that?
Yes, sir.
Okay, I'll allow you to pay it $75 a month, first payment being 30 days from today, okay?
Yes, sir.
Then you'll need to meet with a probation parole officer over here.
And Judge, I'm gonna tender a DUI plea here in just a second.
Okay. Well, he already entered the plea.
He's entered the plea. We
Okay.
just need paperwork.
Yeah. Okay, now is James Wolverton here? It appears James Wolverton has an active warrant out. Is that correct?
That's correct. We'll try to find him now.
Okay, let's go to Barron County, Barron County Correctional Institution Detention Center. Commonwealth versus Timothy Curtis. Are you Timothy Curtis? Are you Timothy Curtis?
Yes, sir.
Okay, good morning. We're here on 25 CR 004 for arraignment. Mr. Curtis, were you born in 1978?
Yes, sir.
Last 4 digits, social security number 1511.
Yes, sir.
Okay, you have a right to remain silent. You are representing the Office of Public Advocacy. Your attorney is here. The grand jury of Monroe County has indicted you as being a persistent felony offender in your trafficking charge. You understand that?
Yes.
Okay, Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We schedule a negotiation day for April 7th, and the next court appearance is April 17th.
Yes, Your Honor. Thank you.
Okay,
Is it April 4th?
April 4th.
April 4th, excuse me. Yeah, I've got to read that. April 4th.
Yeah.
what did I say, 6?
Yeah.
Yeah, April 4th and the 17th.
Yes. Thank you, Your Honor.
Tquan Howard for arraignment. Are you Tquan Howard?
Yes, sir.
Born in 2004.
Yes, sir.
Last 4 digits, social security number 1655.
Yes, sir.
25 CR 00012 for the purpose of arraignment. You have the right to remain silent. Grand jury of Monroe County has returned an indictment charging you with aggravated trafficking in controlled substance, first degree, first offense, trafficking in controlled substance, possession of marijuana, and possession of drug paraphernalia. You understand those charges?
Yes, sir.
Okay. Mr. Bell, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, and if you're not guilty.
Yes, sir.
Okay, we have a negotiation day on April 4th, and next court appearance on the 17th. I signed a reciprocal discovery order at some juncture here with Mr. Howard. I can come up, provide you information to help prepare for your defense.
Judge, we put a motion on today simply asking the court pursuant to Kentucky Revised Statute 431-535. It's our position, Your Honor, and had it held in many other courts, that a person's entitled to have their cash bond also be a property bond, if it's doubled. So we're just asking the court to amend his bond to 25,000 cash or 50,000 property.
If the court does that, I just asked him to be on restrictions, curfew, Your Honor.
Well, he'll be on curfew, stay at his house, work, church, doctor like everybody else is.
And he's got a job at Accabono. He'll be going back
That'd
there.
be good.
Pending test results, I might come back and move the court to alter bond. I just want to give you a heads up.
Do what?
Pending the test results in this case, I might come back and ask the court to alter or amend the bond.
Well, you always can do that.
Yeah.
I'll make the terms of the bond 25,000 cash or property. And to make a $25,000 property bond, you have to put up $50,000 worth of clear real estate.
That's correct, Judge.
Okay,
Yes.
thank you very much.
Thank you, Judge.
Yeah. Chandler Moon. Cromwell versus Chandler Moon, 24 CR 0013. Are you Chandler Moon?
Yes, sir.
Okay, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced today? On a plea of guilty to selling or receiving a vehicle with VIN numbers altered, he shall receive 3 years. On a plea of guilty trafficking in stolen vehicles, should receive 3 years. On a plea of guilty receiving stolen property less than 10,000, he'll receive 3 years. The 3-year sentence will run concurrently for a total of 3 years, probate for 3 years, supervised in the state of Tennessee. This 3-year sentence shall run consecutively to the Tennessee case that he's currently on probation for. Defendant agrees to remain outside the Commonwealth of Kentucky unless approved by Tennessee probation and parole. Defendant agrees to forfeit $80 to Commonwealth, agrees to forfeit the black Ford Taurus, another black Ford Taurus, and 2 pages of items incorporated by reference to Fountain Run Police Department. Is that correct?
Yes, sir,
What's
Judge.
the court cost in this case? $295, and it needs, since you're out of state person, you need to, can you pay that today?
Yes, sir.
Okay, we pay the $295. Clerk's office here, and when will he come under y'all's supervision and you transfer him to Tennessee?
Yes, Monday, when he gets out, if he comes see me Monday, we can transfer his case to.
What time do you want him to be there?
10 o'clock.
I was hoping he'd get out today.
He's not gonna get out today till we get him signed up. Thing.
Chandler, I apologize, bud.
We gotta get you signed up. I'll let you out, have somebody over there at 8 o'clock on Monday morning. And they'll take you up to the probation and parole office. They'll get you signed up and transfer you down there. Is that right, Mr. Parole Officer?
Yes, sir.
Okay, thank you very much. Timothy Shirley. Commonwealth versus Timothy Shirley. Are you Timothy Shirley?
Yes, sir.
Good morning. We're here
Yes,
on
sir.
24 CR 0028 and 21 CR 0058. Were you born in 1969, Mr. Shirley?
Yes, sir.
4 digits, social security number 6465.
Yes, sir.
Okay, what does the Commonwealth have to say?
I don't know why Mr. Shirley's being held. Not on bond in this case, and
Probably got something else in district court. I don't know that.
I looked him up. I don't see any new charges. There was a misdemeanor charge that he was revoked on last year, but that charge was dismissed and he was reinstated. His bond was reinstated.
The only thing I know is Mr. Shirley is on here on a pretrial conference and a probation revocation, what it says.
In pretrial, tell us why he's incarcerated.
Telling here he's on for probation. Oh, 621 CR. 58.
You didn't ask for probation.
That's the last time he was in, that was from
I think that's fair, Your Honor. I think.
What are you doing in jail, Mr. Shirley? You know?
I don't know, sir.
I guess I'm supposed to tell you that, right?
Well, he had an assault charge that was dismissed and the probation should have been lifted and harassment.
Can he get out today?
Yes.
You can be on your way rejoicing. I'll sign an order letting you out. Is that okay, or you want to stay?
I don't think.
No, I'm ready to go.
Just a
Well,
detainer. I don't see there was ever a warrant issued.
Why, how do they hold him?
I showed the last warrant was served in September of 24.
And that was when he got the misdemeanor that was since dismissed and he was reinstated. I don't know why.
Check with the jail, Mr. Brown, and see why they're holding him and let me know.
I'll send a release order from here, but your attorney will have to check with the jail to see why if somebody else is holding it.
Okay.
We're not holding it.
Well, we can do a notice saying that we have no authority to hold him or something. We got to send them something.
Not us. If it's a detainer, probation parole has to.
Take care of it right now, finding out what it is here.
Because we have not, we have nothing holding.
Well,
The jail workplace, they do reinstatement.
well, we'll let them figure that out. We don't have anything on him here is what you're saying. So, if I was you, this close, I'd wait till after lunch. I'd get a free meal off of them before I got out of there.
All right.
Okay.
We still have.
Yes, Judge, I talked to Mr. Stockton. We agreed to reset this to June 12th.
If we can, because I'm waiting on the Chad Shirley case to be concluded before I deal with this case.
Okay, well, let's schedule his next appearance here on April the 4th.
June.
June?
Yeah, they're gonna be trying Chad.
June
Shirley.
what?
Well,
You don't want a negotiation date? What?
no.
June 12th is the next court date when you get out.
Your Honor, he's being held here at the jail because we never got paperwork to release him. We never got anything else after the warrant and the bond. We never got anything else.
There was no warrant served according to.
That'd be a district court warrant. We don't, what kind of warrant do you have?
That's what it was, the district, but we never got anything releasing him. We don't even have anything showing that case was
Okay,
dismissed.
wait just a second. So you'll need to get with the district court if that case has been dismissed.
It has.
Okay, well, I know, but you need to get the document saying it's been dismissed and send it over there.
Send it to the jail?
Well, if you want him out of jail, I don't know where
We need to
you,
get a release order from the district court that he's
Yeah.
been dismissed. We can't release him because he's been held in district court.
it's a district court warrant.
Sheriff's Department can take care of it.
Okay,
Okay.
thank you.
Tamara Stamper,
Is he on for April 4th?
No.
June 4th.
Tamara Stamper.
Yes, I'm here.
Good morning.
Good morning.
Ms. Stamper, were you born in 1985?
Yes, sir.
Last 4 digits, social security number 1699. Yeah,
Yes.
right. So, do you have an attorney? Right,
Johnny
Johnny Bell, is this one of yours here? Ms. Stamper, you don't have her? Can you afford an attorney, Ms. Stamper?
No,
Okay, I'm gonna appoint public advocacy and pretrial will go over and have you send an affidavit just to double check that. Public advocates want to step up here. The grand jury of Monroe County has charged you with operating a motor vehicle while being revoked. operating under the influence, aggravating circumstances, possession of drug paraphernalia, possession of controlled substance not in the original container, failure to maintain insurance, and careless driving. You understand those charges?
Yes, sir.
Okay, you acknowledge the identity of your client, receive indictment, wait formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. Ms. Stanford, Commonwealth will be required to provide your attorney information to help prepare for your defense. Scheduled for April 4th. For negotiation day, the next court date's April 17th. How much is her bond?
She also has a Savannah player.
You got other holders from other counties, so there's nothing I can do about the bond.
Okay, if you can, let me sign myself out from here, I can take care of my stuff in the other counties.
You need to talk to your attorney, and if she can work out anything with the Commonwealth, I'd be glad to go along somewhat, okay?
Okay, got it. Can I talk to you now? Okay.
No.
Yes, ma'am.
Wait. Your
Ms.
attorney-
Stamper, we
wait,
will be
you
over.
Wait just a second.
Sorry.
Your attorney will be over to see you right soon here today sometime.
It probably will not be today, Your Honor. It will be soon, but it will not be today.
Well, when will it be?
I am unsure.
Okay,
Wait.
if y'all can. I'm on lower.
Wait just a second.
Okay. I'm sorry, Judge. I'm ready to go home. I apologize.
Be quiet.
Okay.
Holders from what other counties?
I shot one for Madison, one for Fayette.
What were they for?
They're Santa, one of them paid today, it's gonna pay $878. So they're out. No, their restitution $368. Your freaking insured bond in this case increased it to a cash bond.
What does the Commonwealth feel about her having a surety
I
bond?
don't want to project, she's got the DUI for.
Okay, well, once your attorney comes over and talks to you about it, we could address the bond at this time. Thank you very much.
Thank you, too, Judge.
Yeah.
Okay, am I free to go? Okay.
Benjamin Tully.
Okay, thank you.
Commonwealth versus Benjamin Tully. 24 CR 0020, 21 CR 0093, 21 CR 0092, 20 CR 005 ER Benjamin Tully.
Yes, sir.
Born in 1987.
Yes, sir.
4-digit social security number 2174.
Yes.
Okay, what do we have? What's Commonwealth have?
Mr. Bell's requesting one more pretrial conference, and I'll agree to one more.
Pre-trial conference on April the 4th, negotiation day rather on April 4th, and next court appearance on the 17th. If it's not settled by then, we'll set a jury trial, okay?
Yes, sir, Judge.
Michael
Good
Turner,
day,
your
Judge.
attorney to be oversee you, Mr. Tully. Michael Turner. Commonwealth versus Michael Turner. 23 CR 0055. Is Michael Turner in there?
He's going to get in, Your Honor. He wasn't on the big list. He's going to get in.
I don't know if you want him to go get him, because I don't know if we can hear this.
Well, it'd be up to what Mr. Brown says, I guess.
What story?
Well, he was evaluated by KCPC. He was found incompetent. And he refused treatment. They thought they could restore competency, but he refused treatment. And for whatever reason, they didn't want to administer treatment involuntarily. So I'm asking for a court order to do that because this is a serious case because.
What's he charged with?
He's charged with trespass and burglary. This is the man that thinks he owns land.
Oh, yeah.
And I'm afraid there's going to be bad trouble over this if something's not.
I never have seen a forced treatment.
I understand that they're going to be filing something in district court. I believe district court.
We are, but I think this is the key problem is he won't accept treatment. And I think we're just punting it down the road if he doesn't get treatment.
What statute allows forced treatment?
I don't know if we can do it or not, but evidently in the KCPC report, they didn't want to do it. They've done it before, but they didn't want to do it in this case. So I've got the doctor lined up in 2:30 to test if it ain't there.
Okay, well, we'll just We'll just continue this case till 2:30 today and pull him back up. Okay, thank you. David Wood. Mr. Turner, the doctor is going to appear at 2:30 to testify in your case since you won't allow them to give you treatment. We're going to have a hearing on whether we're going to force treatment on you or not, okay?
I've got been evaluated 2 or 3 times, or 3 or 4
No,
times.
I mean, this is emotional to be heard, and you talk to your attorney if you want to testify today. We'll allow you to testify. Thank you very much. We'll see you.
I've never seen him yet.
Hey, I'll see you at 2:30. I'll see you at 2:30. I will see you at 2:30. Thank you. Thank you. David Wood. Commonwealth versus David Wood, 19 CR 00108. David Wood says represented by Johnny Bell. Is that right? Okay, we got a new attorney in town here. It's 19 CR 00108. Are you David Wood?
Yes, Your Honor.
Were you born in 1981?
Yes, Your Honor.
Last 4 digits, social security number 2810.
Yes, Your Honor.
Okay, what do we have here? Motion for shock probation.
No.
Shock probation revocation.
Yeah. Your Honor, it's a motion to revoke shock probation. And after discussing this with Officer Collins, he's had about 8 or 9 violations on his shock probation since July of last year, and the Commonwealth's asking that he be revoked.
Clayton.
Judge, let me explain for the record. So we had originally tried to negotiate this, but because he had already been to drug court, he can't qualify for that again. So they're moving forward with the motion. What I would ask the court to do is permit us to have a hearing. His mom is here. We would like to introduce some testimony about his medical problems.
Okay, we'll have a hearing. You are stipulating the violations, and then you want to have a hearing. You want to present evidence to.
Yes.
Okay.
I think the court needs to
Be aware of the violations and then they can
Read the violations.
On July 10th, 2024, admitted to using meth. July 28th, 24, admitted to using meth and marijuana daily. July 29th, home visit by Officer Collins, found marijuana and drug paraphernalia. July 31st, he was supposed to go to outpatient program Fuller Life. He started Fuller Life on August 9th, 2024. He was discharged from Fuller Life on 9/12/24. He was a no-show. He was only there 2 weeks. He failed to report to Chase Collins on September 16th, 2024. Chase conducted the home visit. He couldn't find him. He never reported, listed as an absconder. And then he got a new felony arrest on 12/15/24 when he had a half a gram of meth in his possession.
Judge, some of those have already been addressed by the court. I think the most recent violation was the possession, and there was an absconding as well. I understand that, Judge. I understand that.
What's the testimony going to consist of?
Judge, his mother is here. He has a bone disease called osteogenesis, where, Barbara, can you come up here for a second? It may be easier if I just have her to explain it, Judge. Can you state your name for the record?
Barbara Sue Wood.
And how do you know David Wood?
David is my son.
Okay.
Raise your right hand. You swear the testimony about to give us the truth, the whole truth, nothing but the truth.
I do, Your Honor.
Go ahead.
Can you explain to the judge what osteogenesis is and what type of problems David has had?
Osteogenesis is a congenital bone disease, which he has had. He was diagnosed when he was 8 years old. He was in the hospital so many times and he got addicted to morphine. He was on a morphine pump for pain. And he constantly had to have something to control the pain. It was so out of control. He has had I'd say about 28 to 30 broken bones. And he hasn't been able to participate in any kind of sport or have a life like any other ordinary child. And
What exactly is osteogenesis? What does that do?
It's called a brittle bone disease. His bones, he has plenty of calcium in his body.
I'm familiar with it.
Okay, thank you. He's not had a life. He's not had I've given him as much support and he has tried so hard, Judge. He has tried. I mean, you don't know how unbelievable this has been for both of us. He's the only thing that I have.
If the court were to try to give some sort of alternative sentence, whether it be a super lengthy home incarceration or anything else like that, would you be willing to let him live with you and
Absolutely,
do whatever the court ordered?
absolutely.
You have any questions?
No.
Okay. You have any other testimony?
Mercy.
No, Your Honor.
Okay. Make your argument. Thank you, ma'am. You can return to your seat.
Judge, the Commonwealth has attempted to work with Mr. Wood. And it's unfortunate he has this health disease, and he's had problems, but there's no excuse for not reporting for over 3 months and then getting a new felony arrest. I don't know how you work with somebody that way. I mean, you have to put forth some effort.
Judge, if I might. Judge, what I would ask the court to do, in lieu of revoking him, have him to serve an alternative sentence of 180 days on home incarceration, or if the court even deemed appropriate, even a year.
He's proven to me from the evidence and the stipulations that he cannot be supervised. He will not comply. Now, what's the total amount he's got on?
It's a 5-year sentence on wanton endangerment first degree is what he has.
Yeah. And he'd be eligible. What? He's got some.
He'd have to serve 9 months before he's eligible for parole.
Yeah, I think that's the best route for him to get out on parole. If he doesn't make parole, he's on shock probation revocation.
Can't shock him again.
I can't shock him again, so we'll just see if he makes parole.
And
Okay.
Judge, could the court have the record to reflect that's a 20% parole eligibility, just so DOC doesn't mess it up?
Yeah, it's not in reach.
But it is what it is. If they mess it up, you can come back and get an order. I have not direct anything to what the correction cabinet does. So it is what it is. Okay. Thank you very much. Do we have anybody else there in Glasgow and Barron County that wants to hear us?
That Benjamin Tully.
Thank you very much. Till 2:30, I guess, right?
She said we had Benjamin Tully, but we've already done this.
We already did Benjamin Tully.
Oh, I'm sorry. That's all we have.
Okay, thank you very much. You're excused. That concludes the morning criminal,
So close.
except for the show calls. Where's the show call? Okay, here.
I don't know that I ever got it out.
Okay.
What do you do?
Commonwealth versus Tracy Davis. Tracy Davis. Owes 200 and tell me something about Tracy Davis. Issue a warrant, can purge himself paying $215. Catlin Garrix. Do what? Okay, issue an arrest warrant. Purge themselves by paying $1,290. Warren Gayer.
April 17th.
Made a payment. Joby Grace. Hello. So order says you to pay $250 a month.
Yes, sir.
You haven't been doing that. What's the story?
I've been incarcerated. I just started drug court last month and paid about.
Where are you going to drug court at here?
Here.
That's true. Okay. He had some co-defendants that were supposed to pay also. I'll give you 30 days to pay this payment.
I did make a payment last week on it. I did make a $50 payment on it.
Do what?
I did make a $50 payment last week.
Yeah,
on
but
it.
it's $250 a month, so I'm gonna reset the clock for you, and you start paying $250 a month, starting a month from today. We reset the clock, since you're in drug court, you gotta work there anyway, okay?
Yes, sir.
Tyler Graves,
April 17th.
okay, put him out to next month. April 17th. Damian Hurt. Damian Hurt. He's one of the people supposed to be doing co-payments on that with the other guy, right?
202A191 requires.
Well, let him
promulgate
issue a bench warrant telling him he needs to pay $500, purge himself. That's two payments, right? Correct? Okay. Timothy Jones. Oh, 3235, is that correct? When's the last time you made a payment?
You just not pay this month. It's kind of full.
And give him, have to pay 300, the rest $300, that's two payments. Purge himself. Charles Muse,
$145, April 17th.
continue to April 17th. Ashley Pittigo, April 17th. Jamie Piercy,
He was on the morning call again.
It's the one with child support we set out till June.
have put him back on the docket for June. Well, he's released though, what?
He's out.
He's out. Well, go ahead. You go back to Jamie Piercy, tell him, this morning, purge himself, paying $235. Austin Pruitt. Okay, 17th. Travis Smith,
$300.
17th. And Shawandra Warren.
$30.
Okay, exactly what the show calls docket. Is there anything else to come before the court before the 1 o'clock child support docket? Here we are in recess till 1 o'clock.
Grand jury.
Is the grand jury finished?
Yes.
Bring the grand jury, I guess.
Got my Jerry.
Off the record while we wait for the grand jury.
Oh, okay, just do it.
Call it child support docket. I don't think it is. It told you.
I've heard that, yeah,
Okay.
I said the same way when it come in.
Clary versus Clary.
Thank you.
You swear the testimony about to give us the truth,
Yes,
the whole truth,
yes,
nothing but the truth.
yes, sir.
Okay.
State your name for the record, please.
Sarah Guthrie?
And you're employed by the Monroe County Child Support Office?
Yes.
And you're familiar with the case of Melina Cleary versus Preston Cleary, 17 CI 177, is that correct?
Yes.
And Mr. Cleary has an arrearage of $8,863.20 as of today, is that correct?
Ms. Cleary, yes.
She's the one who has, okay. And as far as you're aware, she's an able-bodied person capable of providing the support. She's neither incarcerated nor a member of the armed forces, is that correct?
Yes.
And she was given notice of the hearing and is before the court.
Yes, sir.
Judge would ask you to adjudicate her arrearage, hold her in contempt and allow her to purge.
How much you want to,
$2,000 lump sum payment. She owes $8,863.20.
where does this person live?
Okay.
Here in 2215 Lions Chapel Road, Tompkinsville.
Is she employed or anything? Or what's the story? Y'all know?
We never get a response unless we bring her to court.
Does she pay usually when you?
She last made a payment. She quit making payments in 2023. She was making weekly payments.
These are all arrearages now, the children and adult,
No, she still owes $269.10 per month.
she's not paying that.
She hadn't made any payments since November 16th.
Okay, submit the order. Crawford versus Crawford.
Continue until April the 17th.
Okay. Russell versus Curtis.
April the 17th, please.
Fox versus Fox.
April the 17th, please.
How much is owed on Fox versus Fox?
Last time I don't have it this
She
time.
looked it up last month and brought it and we discussed it, but I can't remember it.
I think it's like 3,000.
Well, I mean, it's been a 12.5 year deal for me here, you know. Graves versus Graves.
April the 17th, please.
Guffey versus Guffey.
April the 17th, please.
Okay. Turner versus Guffey.
April the 17th, please.
Hammer versus Hammer.
April the 17th, please.
Heston.
April the 17th, please.
Heston versus Heston.
April the 17th, please.
Taylor versus Houchins.
April the 17th, please.
Hudson versus Hudson.
April the 17th, please.
Jimenez versus Jimenez.
April the 17th, please.
Joyner versus Joyner.
April the 17th, please.
Dye versus Jones.
April the 17th, please.
Jones versus Jones.
April the 17th, please.
Page versus Page.
April the 17th, please.
Pennington versus Pennington.
April the 17th, please.
Rich versus Sean.
April the 17th, please.
Brown versus Scott.
April the 17th, please.
Wilson versus Shelton.
Ms. Guppy, you're still under oath. You're familiar with Monroe Circuit Court case number 24 CI 55. Terry Shelton is the parent who owes the money. Is that correct? He is before the court and given notice of this hearing. Is this correct? There was an order entered ordering him to pay $388 per month. Is that correct?
Yes.
He's never made a payment. Is that correct? He currently has an arrearage of $25,459.12. Is that correct?
Yes.
And he, as far as you're aware, he's an able-bodied person of providing the support. He's neither incarcerated nor a member of the armed forces. Is that correct?
Where does he live?
I think it's Mudlet. We've had this case before.
Yeah.
And then he moved out of the county. The arrearages occurred outside of our county.
Yeah.
And then he moved back here somehow and they transferred it to us. So this is our first attempt at enforcement after getting him served.
How much you want?
$5,000 a month or down lump sum and then $500 a month towards the reduction of the arrears.
Yeah. You know, when we first started district court, we switched over to district courts. A. Thomas Davis here was one of the first district judges. He grew up in Louisville. So he was sitting over in Cumberland County. I went up there and I hadn't been licensed yet. I was still in law school and I was listening to what I was doing. And one of the requirements he put was for someone to pay a certain amount on their fine and to get their GED. So I went downstairs and they said, well, how's the new district court going? I said, well, I just saw Joe get a life sentence. He'll never get his GED. And that might be this $5,000 per lump sum payment. I mean, it might cost the county quite a bit, you know.
That's, some of the drug court participants, the GED is.
I'd hate to try to do it right now. I wouldn't want to do the math part of it, so Smith versus Smith.
April the 17th.
Right. Moore versus T-Shop.
Ms. Guppy, you're still under oath. You're familiar with Monroe Circuit Court case 22 CI 80. Is that correct?
Yes.
Mr. David Teachout was ordered to pay $198.50 per month. He's never made a payment. He owes $3,970. Is that correct?
Yes.
And as far as you're aware, he's an able-bodied person capable of providing the support as previously ordered. He's neither incarcerated nor a member of the armed forces. Is that correct?
Yes.
Judge, we'd ask you to adjudge his rear, hold him in contempt, order him to pay a $750 lump sum payment plus $100 per month.
Sounds reasonable.
With a reduction of arrears.
Vincent versus Vincent.
Judge, this is an order to modify child support, medical, and wage assignment based upon the Kentucky child support guidelines and the income provided to us by both parties. It decreases from $362.40 per month to $287.97 per month. We ask that go back to March 1st. It just helps the bookkeeping. And there is no arrearage owed at this time. Both parties are aware of this and chose not to attend today, but we submitted an order based and the work showing how we got this order.
Okay.
All right. Thank you very much.
Thank you very much. Let me ask you just for my own information, what sort of access do you have to pay records for somebody that you're dealing with?
Ms. Staples, what is the income?
Come over here where I can hear you.
What is the program we can find out people's pay rate?
Eligibility advisor.
And then what'd
you say?
Eligibility advisor.
Quarterly, whatever they make each quarter is entered into the system based upon the pay.
Well, I've got some cases that aren't on the child support docket, but now that we don't have a commissioner, I hear different sorts of things. And I am suspect of how people might be avoiding pay by, doing deferred comp or doing other things like that. Does that system show up what the gross pay is or
It does this.
What's the name of it again?
Eligibility advisor.
Eligibility advisor. And then do you have to enter the employee and employer's name in it or?
You just enter their social.
The social when it comes up. Well, that's a little scary, isn't it, that they have that kind of information about everybody? Well, okay, well, maybe some of these people are, and everybody has access to that program?
No, it's through the child support.
Through the child support. So if someone suspects the numbers are not cricket, then they can ask y'all to take a look at them, right?
Correct.
Okay, well, thank you very much. Okay, Donahue versus Donahue.
Hi, Your Honor.
Hello. Wait
Spencer
till these
Pierce.
folks get up here,
Sorry.
okay? Okay, could you identify yourself?
Yes, Spencer Pearson. I'm attorney for petitioner Josh Donahue. And it's our motion. We have two motions on for today. One is to get a hearing date for modification of custody. There's been some developments in regards to the CPS investigation. And so we would like to get a hearing date for that. And then we also have a motion to reinstate the child's telephone access. She hasn't had access